Good morning and welcome to another edition of the Senate Committee on Commerce and Labor. Madam Secretary, please call the roll.
Senator Buck? Here. Senator Daley? Here. Senator Hammond? Here. Senator Lang? Here. Senator Pizzina? Senator Scheibel? Here. Senator Stone? Here. Chair Spearman.
Thank you. Please let the record show that all the committee members are here. A couple of housekeeping items. You already know there are several different ways you can participate: in person, telephonically, send a written comment, or you can voice your opinion on the opinion website. I'd like to say to everyone that we've got several bills today, and I'm going to ask you all to please, if someone has already said what you need to say, just say ditto, because there are several people standing in line behind you, and they will not be able to say anything. The next thing that I want to say is that pursuant to NRS 218E.085, it is unlawful for anyone to knowingly misrepresent facts when testifying before a legislative committee, and anyone who does so is guilty of a misdemeanor. The chair or any committee member can ask you for documentation to back up the facts. And finally, please, ma'am, please, sir, turn off anything that sounds like you can make a pie with it, an apple, a blackberry, or anything. Even if it doesn't sound like that, turn it off so it doesn't interrupt the flow of things. Have I said everything? I think I've got it. So why don't we get started with Senate Bill 139. The measure exempts certain persons from provisions governing the license and regulation of persons engaged in the business of lending. Mr. Erb? Yeah, come on. You have, as I understand, you have someone in New York? That's on? In Florida? Okay, somewhere in the U.S. there's someone who's going to join us via Zoom. Okay. All right. Okay, so Senator Hammond, you all begin when you're ready.
Thank you, Madam Chair. For the record, Senator Scott Hammond, representing District 18, here to present Senate Bill 139 to you and the rest of the committee, the esteemed committee this morning. Everybody's awake and smiling. No, not really, but that's all right. We're all here. So as I want to keep it brief, keep the comments going, and just kind of talk about the bill. So the first thing I thought we'd do is we do have Ms. Susanna Albright, who is on Zoom. This bill deals with lending, and I thought that she might be able to explain a little bit about the rationale for this, and then afterwards I'll turn it over to our former colleague from the Assembly, Mr. Irv Nelson, to kind of go through the bill, through the sections of the bill. So if we could, at your discretion, Madam Chair, go to Florida and talk to Ms. Albright.
Yes, ma'am. I think you're muted.
Thank you. May I proceed, Madam Chair?
Yes, please proceed.
Okay. For the record, I am Susanna Albright, Chief Executive Officer of a family-owned financial company that makes commercial loans to small businesses throughout the country and hopes to expand into Nevada. Thank you, Madam Chair, for hearing SB 139, and thank you, Senator Hammond, for sponsoring this bill to place Nevada businesses and commercial lenders on an equal footing with out-of-state businesses and lenders, to make a clear declaration of public policy, and to open more avenues for Nevada companies to get financing necessary to operate, compete, and grow their businesses. Senators, the company I run is a small part of a large industry that's called the alternative lending industry, a diverse set of small business financing platforms and other small business stakeholders interested in the health and success of the small business economy. In the wake of the financial crisis of 2008 and the Dodd-Frank Act imposing restrictions on traditional interstate banks, small businesses have increasingly turned to alternative lenders for the capital needed to fuel their growth. Capital is key to small business success, as you may know. Whether it is adding a new salesperson or starting a new contract, the small businessman or woman can only make those moves with some extra money to pay for that expansion. Businesses in the $1 million to $5 million range in sales particularly feel this pinch. A typical path through that particular phase is for the need to shatter their original mold of founder as chief, cook, and bottle washer, and to start to develop the differentiation of sales, marketing, operations, and accounting that characterizes large corporate structures and adds jobs. In this stage, they're too big to rely on credit cards or to request a loan from their friends or families. Most of us do not have friends who can loan us $100,000, but they are also too small or unstable to qualify for traditional bank loans, or they cannot wait for the 60 to 90 days or more that it takes to do so. According to some estimates, there are likely thousands of alternative lenders like ours lending to small businesses for these reasons. Alternative lenders are happy to take credit risk. That's what we do, but we cannot take legal risk. And legal risk is why companies like ours have run into a problem making loans here in Nevada. I believe I speak for many alternative lenders like ourselves. The statutes here, or lack thereof, prevent lenders from making loans to small businesses here, a problem you are in a position to remedy. First, it appears that some courts in Nevada and other states have ruled that even if the contractual intent of the parties in our contracts is for Nevada law to apply, the law of the borrower's state can control a lending agreement if that state has a public policy saying so. In other words, financial services companies headquartered in Nevada cannot be assured that Nevada law will actually apply to their contracts. Second, there seems to be an open legal question as to whether commercial loans made to Nevada businesses are subject to Nevada consumer protection statutes. Protecting consumers from predatory lenders can and should be a proper topic for legislators, but businesses are different. We believe an unintended consequence of the current bill, as opposed to a stated public policy, resulted in uncertainty whether lenders can safely, without legal risk, lend to small businessmen and women here in Nevada with their current contracts, the same as in other states. Using our case as an example, when we receive inquiries from our referral network for Nevada businesses looking for capital, which we do receive, we currently have to turn those companies down. In our case, these are companies that literally face extinction if they can't make payroll, something we can help them with in a process that can take less than one business day. For a lender to be able to help a company in need in Truckee, California, but not across the state line in Lake Tahoe City, Nevada, concerns us, and we believe should concern you. You may also be concerned about the costs of alternative lending, and rightly so. I won't go through the many legitimate reasons why costs, and thus rates, are higher for this type of lending. Those can be found in our exhibit to this hearing. I will just say that at our company, 85% of our clients come back to us for repeat business. 85%. The fact that so many small businesses choose to work and continue to work with alternative lenders suggests that alternative lenders have proven to be a valuable resource to the small business economy. Small businesses in Nevada are no exception. Small businesses, in conclusion, benefit from the competition and availability of a broad array of responsibly delivered financing options from both traditional depository institutions and non-traditional alternative financiers. SB 139 will ensure that the array of options remains open to Nevada small businesses. Thank you, and I'm happy to answer any questions.
Thank you, ma'am.
Madam Chair, I'm just going to turn it over to Mr. Nelson to go through the bill real quick, and then we'll stand for any questions.
Okay, can you stay around for a little while?
Yes, ma'am.
Okay, all right. Okay, thank you. Mr. Nelson.
Thank you, Madam Chair. For the record, Irvin Nelson, I'm from Las Vegas, and I will walk through this bill. I'd like to clarify, if I may, one thing that Ms. Albright said. And as full disclosure, Ms. Albright is the CEO of my employer, and I've worked with her for a number of years. She said something that the current bill has unintended consequences. I think what she meant to say was the current statute in place has unintended consequences. Would that be fair? Okay, thank you. And,
Yes, sorry.
no, that's fine, that's fine. And I'd like to compliment Ms. Albright. I lectured her today to say Nevada instead of Nevada, and for the most part, she did. And so I'll just walk through the bill real quickly. I know that there are a lot of bills on the docket today, so I won't go through the long, labored history of this issue, which started in 2017. And other than to say that back then, we had a bill that said very similar to this bill, but because of political issues and getting enough votes, we had to get half a loaf instead of a full loaf. And that resulted in Nevada borrowers and Nevada lenders not being exempt from the lending statutes that outside borrowers, outside Nevada and outside Nevada lenders enjoy. So the unintended consequence was it put Nevada borrowers and lenders at a disadvantage when compared with other states. And it has meant that, as Ms. Albright pointed out, there's some concern for Nevada lenders that are lending for Nevada projects, is the way the statute says it, or Nevada purposes. For example, say, to add more employees in Nevada, or to buy a new widget maker in Nevada, things like that. So we did get the bill passed, but it wasn't 100%. So this bill is to try to remedy that and put everybody on an equal footing. In Nevada, there are a number of statutes that protect consumers, as you know, but this bill only deals with commercial loans to small businesses. And looking at the bill, there are two titles in Nevada law that deal with this type of lending. And actually, all lending, if you read them broadly enough. NRS 604A deals with things like title loans, payday loans, deferred deposit loans, check cashing, things like that, which traditionally have always been considered to be consumer-type loans. And we always thought, I've represented this company for about 15 years, we always thought that none of those really applied to commercial loans. They applied to consumer loans for good reasons. To clear that up, if you look at NRS 604A.250, which is on the second page of the bill, it has a list of companies, lenders, that are exempt from 604A.250, and there's the same exact language in another statute, 675, which deals with installment loans. But they're basically the same things. And the list of exemptions includes banks, savings and loans, casinos, pension plans, loans secured by real property, things like that. They're exempt. And so what we added in 2017 was number 16, which read as passed and signed into law, an exemption for a person who exclusively extends credit to any person who is not a resident of this state for any business, commercial, or agricultural purpose that is located outside of this state. That's what caused the problem I was talking about. In an attempt to, I guess, protect Nevada borrowers, consumers, who aren't actually subject to this, it resulted in an unintended consequence of actually hurting Nevada-based borrowers and lenders. So as you can see, the bill will take out the language "who is not a resident of this state," and also take out the language "that is located outside of this state." so that the exemption, which is available to everyone outside of Nevada, also will now apply to Nevada borrowers and lenders. There's also a clause added, regardless of any personal guarantee or collateral involved in such an extension of credit. And the reason for that is a number of these loans, for example, Susanna's company, they don't take any collateral at all. These are totally unsecured loans. If they go into default, they might file a UCC-1, but generally they're unsecured, but they are usually supported by a guarantor of the principal of the company, which is typical in these types of loans. Also, to address the problem she discussed earlier, there is a declaration of policy. Now, and this is on page 3 of the version I'm looking at. Section 2 of the bill says that 675 is amended by adding thereto a new section to read as follows, quote, "The legislature hereby declares that it is the public policy of this state to promote the extension of credit by persons located within this state to persons located within and outside of this state for business, commercial, or agricultural purposes, and for the laws of this state, Nevada, to govern any agreement by which a person located within this state agrees to end credit to any person located outside of this state for any business, commercial, or agricultural purpose if the agreement so provides." That's a mouthful, and basically what it says is if the lending contract says Nevada law applies, then Nevada public policy supports that Nevada law applies. That sounds like something so obvious that you wouldn't have to say it, but I've litigated a number of these cases in Clark County, and a few of our judges have taken the position that, well, Nevada doesn't have a very strong stated public policy, so, for example, if the borrower is from Florida, Florida law will apply to this. But if the borrower is from New Jersey, New Jersey law might apply. And they're trying to weigh the public policies, and the result is lenders are saying to me, potential lenders, how can we know for sure that Nevada law is going to apply to our clients, to our loans? So that's to choose that. And there's one other thing on page 5 in section 4, and this is what LCB put in. We didn't request this. Oh, no, that's not the right place. It had to do with internet lenders, and it took out the exemption for them. An internet business lender under the statute is defined as a company that... Section 6. Section 6? Okay, thank you. Under the statute, an internet business lender is a company that loans exclusively over the internet. They don't typically have a brick and mortar location. And there's an exception in the statutes for them that they don't have to comply with the requirement in 675 that they have a brick and mortar location in Nevada. And actually, the way that statutes are written, the licensee is the location. It's not the warm body human being, at least the way I read it, which is fine. What that means is if you have 5 locations, you have to have 5 licenses. But so the reason they took this out is because if these lenders, if the bill goes through, they don't need another exemption specifying one for internet business lenders because they're exempt from the whole statute. And I hope that is clearer than the mud outside that's going to start as soon as everything starts melting in the mountains. And either Ms. Albright or I are available for any questions. Thank you.
Thank you. Committee members, questions? Senator Daley?
Thank you, Madam Chair, and thanks, Mr. Nelson, for coming by and talking to me on this. So when I read through it, and when I get to the section 2 and a couple other sections where it takes out who is not a resident of the state, and section 1 and a couple others, so I understand that. What I wasn't following, and maybe it's just a term that I didn't use, when you talk about an internet service lender. And those are stricken out as either we're deleting them completely, or deleting them out of the part where it says they have to get a license. So what's happening to the internet service, or is it covered by some other term that I'm not recognizing or seeing?
Well, pardon me? Oh, yeah. For the record, Irv Nelson. Madam Chair, through you to Senator.
Just go direct.
Thank you. Well, as I understand it, the reason LCB wanted this in is that if the whole bill passes as written, those internet lenders will be exempt anyway, which I think they are right now, if they're out, if they're lending to, if they're outside the state. But so they don't need that. It would be redundant to keep all that in, because if we take out the language that carves out Nevada earlier, then we don't need another specific exemption for internet business lenders in commercial loans. And it's a little bit conceptually difficult because it's an exception to an exemption to a requirement. It's like Winston Churchill said, didn't he say that this is an enigma wrapped in a riddle or something like that? Does that answer your question, Senator? If not, I'd be happy to come by your office for the third time and we can go through the language.
No, it's okay. And I think that makes a little bit more sense, but they used to have to be licensed, and now they're not going to have to be licensed, or they now falling in a different section where they need to be licensed if they're doing business here. So, and I'm not sure, reading the language, and I'm sure it can be cleared up if LCB's got a handle on it. I'll defer, but
Senator Hammond, for the record, Senator, if we wouldn't mind, if the chair would not mind, could we defer to LCB Legal and see why that,
Sure.
how that works? Thank you.
I apologize. What was the question? Sorry about that.
well, we're exempting every reference to an internet business lender is being deleted, various things, including the section where they need to be licensed. So I'm not sure if they're captured somewhere else with the amendment, because they used to have to be licensed, now they don't. Now we're just deleting them. They're exempt from the whole thing. Did they just stop existing, or are they now acting as something else that has to be licensed?
Okay, thank you. They would be exempt from the chapter. So if they're engaging in, if they're making loans, commercial loans in Nevada to Nevada borrowers, they would be exempt from the chapter. So for those commercial loans, they would not be required to obtain a license.
And I guess, this Senator Hammond, for the record, I think part of the rest of the question was, are they, the reason why they're striking out the language in Section 6 is because they're captured somewhere else?
No, I guess they're captured with the exemption. So they were exempted from certain requirements of that chapter, and now they're being now through this language they're exempted they're exempted from certain requirements under existing law, and now they're exempted from all the requirements of the chapter. Is I think the way to put it.
Irvin Nelson, for the record, may I add one thing? Senator Daley, in Section 5 of the bill, the lead into that in subsection 3 is a person may apply for a license for an office or other place of business located outside this state from which the applicant will conduct business in this state if, and it used to say the applicant is an internet business lender. And so the way I read that is, the way the statute's written right now, if a company is an internet business lender, meaning they don't traditionally have a walk-in clientele, then they don't have to apply for a license. And part of that would be they don't have to have a location a brick and mortar location in Nevada. And this is kind of the trend that's going throughout the country. This is the way California's gone, New York has gone, and or they're going that way. And most of the states, I think probably as a result of COVID and everything happening on Zoom or on the internet, are backing off on the, for the most part, on the requirement of having brick and mortar locations.
Yeah, and I think, Mr. Nelson, I think you started with it, but this is a cleanup measure, and it goes back to 2017. We had several bills that session, and this was one of them, maybe 255, by Assemblyman Hambrick, joint sponsor Senator Canizaro. Then we had another bill, Senate Bill 126, that was sponsored by then Senator Ford, that dealt with small and minority businesses. So I think what would be helpful to the members, because I think I may be, Scott, you and I may be the oldest ones on the committee, in terms of length of service. So if you can frame that, starting from this is where we started, and not a whole dissertation, but just, these bills did this, and this, but in hindsight, there were some unintended consequences. So that it doesn't appear that it is an out of the blue standalone bill. Does that make sense to you? Because I think that's where the confusion is coming in. Okay.
Okay. For the record, Irvin Nelson responding, Madam Chair. Thank you for that question. We brought that bill in 2017, and we ran into some opposition from legal aid and consumer protection advocates who were concerned that the bill would harm consumers. And my counter argument was, well, these are only commercial loans. They're not consumer loans. They're not going to affect consumers at all. They don't affect Reg Z, which is a federal law. They don't affect any of the other consumer protection legislation already on the books in Nevada. But we were kind of coming down to the wire, and Assemblywoman Carlson and I worked out this compromise with the people who had the opposition to the bill. And so we said, okay, if we can't get the whole thing passed, and you're worried about Nevada, not Assemblywoman Carlson, but other people were concerned about how it might affect consumers. We said, okay, fine, we'll carve out Nevada so that this new exemption we're adding doesn't apply to Nevada borrowers or loans made for, the statute says, purposes in Nevada, which means being spent in Nevada. And so that passed unanimously, both houses, and was signed by the governor, and everything was fine for a while. But then we realized, oh, wait a minute. This has a big unintended consequence. It's drying up capital for Nevada borrowers, and it's putting Nevada lenders on an unfair footing as opposed to, for example, an Arizona lender. Drive 50 miles and you're exempt from these statutes. So this is actually the third time. In the last session, well, 2 sessions ago, and I'm speaking from memory, so I don't want to commit a misdemeanor by making a factual inaccuracy, but I think it was 2 sessions ago that Senator Canizaro and Assemblyman Hambrick. How can I lose that? Okay. I think Alzheimer's is starting this morning, but Hambrick co-sponsored it, and we didn't get it passed. And then last session, Senator Canizaro sponsored it again, and it came to this committee. And it was a little bit different than this, but it addressed the main points. It tried to take out the Nevada exemption to the exception, or exception to the exemption, and it passed this committee unanimously. It passed the Senate unanimously, and we ran out of time on the Assembly side. I think because of COVID, and I met with Chair Hadigi on the Assembly side, and she had no problem with the bill, but she just had about 100 bills to try to get scheduled, and, you know, kind of like this week, and we ran out of time. So we brought it again. That's how we got here. It's a pretty long, tortured history, and the way I look at this is I can't see anything that would hurt a Nevada borrower or a Nevada lender as a result of this bill. I think it will help all of them because it's going to make credit flow more freely.
Senator Buck?
Thank you so much, Chair Spearman. So currently, can any of these lenders do business or lend to Nevada businesses now? Right now.
Senator Hammer, for the record, to Senator Buck. Yeah, according to the testimony that you've heard, yeah, a lender can still lend right now, but the borrower and lender would be at a disadvantage, again, because of outside laws that exist, and we don't have a statement of policy in our statutes that would help secure, at least legally, the side of the lender, and so that's kind of why we're here.
And currently, Nevada law protects these personal loans with consumer protections, the personal loans, so that's separate. Then the commercial loans, which are subject to the laws of wherever the lender is. Am I correct?
Yeah, for the record, Irv Nelson answering Senator Buck. Yes, that's accurate. Now, as with any legislation, hearing an explanation from a lawyer, the real answer is it depends. And the reason I say that is because if you get into the weeds and read the statute, 675, it is against Nevada law to make these commercial loans to Nevada borrowers without being licensed under 675 unless it's like a one-off thing or you know, I forget the exact language, but like occasional, I think, is in there. So if it's like, you know, one loan a year or something like that, there's a good argument that they don't have to be licensed. But if they start doing more than that, 675 says it's a $10,000 fine if you do it without being licensed. That's why people like Ms. Albright have retained me, and we're trying to fix this problem.
So can you,
and-
oops, sorry.
Oh, I didn't want to interrupt you, but the second part of your question, again, Irvin Nelson for the record. Yes, consumers are protected. This only deals with commercial loans to businesses.
So can you clearly contrast the personal borrower protections with the commercial lending protections? Are there commercial lending protections in place?
Irvin Nelson for the record to Senator Buck. The consumers are well protected under state and federal law and regulations and case law, I think. And Reg Z is a big one that applies to all of those. And for example, credit cards and things like that, home loans, that's all very highly regulated. Under NRS 99.050, commercial loans can have whatever terms the parties want to have. For example, well, that's actually why a number of these companies come to Nevada, is because there's not a limit, generally speaking, on what they can contract for. It comes down to competition and loan underwriting. But there's also a law that says if the language is not clear, it's in essence unenforceable. So that's a protection right there. And then you have the common law fraud and no meeting of the minds, things like that you can rely on.
Do you know what percentage of these loans are defaulted on?
For the record, Irv Nelson answering Senator Buck. I might defer to Ms. Albright on that. For her company, I think it's around, was it 8% or less?
I'm sorry. I couldn't hear the question.
What's Irv Nelson to Ms. Albright? What's the average default rate of these types of loans in your experience?
For the record, Susanna Albright, through the chair to Senator Buck, I guess. It's, that's actually a number that's considered proprietary and confidential, but it's high, higher than a bank, for instance. And it's in that range of, I would say in that 10% range.
Irv Nelson for the record, but it's lower than I think most of us would anticipate for an unsecured loan that's sometimes made in 24 hours.
I only asked that question because I'm trying to see if that is potentially an issue that you would have to go to the court to find out what state that the original lender's from. I mean, I don't know.
Irv Nelson for the record, responding to Senator Buck. Yeah, that's exactly why we're bringing this, because every state has its own law.
Vice Chair Lang?
Hi, my question is, if you don't have a brick and mortar facility and you don't have to get a business license, does that mean you're also not paying Nevada taxes, business taxes?
Irv Nelson for the record. I would ask LCB that, because I think, actually, I think under the tax law that was passed in 2015, that those would be taxable, because part of the reason that tax law was written and passed was to capture outside revenue, and Nevada's economy had changed from gaming primarily to service economy, and that's part of why I voted for that bill. I don't know if LCB has anything to say about that.
So, yes, and I think the reference being made is to the commerce tax under Chapter 363C, and that would apply to persons engaging in business in Nevada, including out-of-state businesses that sell, that provide services to Nevada residents or sell products to Nevada residents, and that would apply if the gross revenue from engaging in that business in Nevada to Nevada customers exceeded $4 million. So I think that would be a tax applicable to businesses making loans to Nevada borrowers if the gross revenue from loans to Nevada borrowers exceeded $4 million in a year.
Yeah, okay, just, so, if I remember correctly, in 2015, the overhaul of the tax codes had to do with businesses would be categorized under, with NAICS, North American Industry Codes, is that it? Yeah, so whoever's doing business in Nevada falls under one of those codes, and that's what their BMT would be, or their taxable rate would be. So it wouldn't matter where they were. It really matters where, and Mr. Fernie, correct me if I'm going too far, but I think it matters what they do, because the NAICS code really controls that.
That's correct, and the tax applies to persons engaging in business in Nevada, and that would include selling products to Nevada residents, providing services to Nevada residents, providing services to Nevada businesses, and the rate is based on the industry in which the business is engaged, and there would be a category for, you know, financial services that would have a rate specific to that industry.
If I may add, Scott Hammond for the record, what we want is we want them to be making more money. We want them to be engaged more in business so that that next code that we were talking about, you know, they actually do pay more, the payroll tax and the commerce tax. So that would be the end, you know, the goal here is to actually get more business, more revenue into the state.
For the record, Irv Nelson, if I may, you know, also, a number of these lenders actually do have brick and mortar locations here, including Ms. Albright's company. So there are some advantages to obviously to being here and having records and things here.
And I think to your point, Senator Hammond, working with the then Governor Sandoval and his folks, were trying to make sure that the commerce tax and the way it would be rolled out would be fair to Nevada residents and fair to lenders or anyone else who is doing business, which is why we came up with the, and Mr. Fernie, correct me, I may be over my skis on this, but the NAICS code would make it would make it more equal across the board without having to go back in and say, so what does this business do? Now let's go down a list of 30,000 names and figure out who it is. And the reason for the tax overhaul in 2015 was because our revenue stream was solely and wholly dependent upon gaming. And every time there was a fluctuation in gaming, then there was also a fluctuation in taxable revenue or income. So the NAICS coding was the way to make it equal and standardized, so it didn't matter what you did, it had to fall under a particular code. And based upon that code is what your taxable income or your taxable assets would be. Is that correct?
Correct. Yeah. The tax rates are varied based on the industry, and I looked it up, and the tax rate applicable to financial services is 0.111% of gross revenue, Nevada gross revenue in excess of $4 million.
Senator Stone.
Thank you, Madam Chair, and thank you for the presentation. Just want to make sure I'm understanding everything right. Is the primary premise of this bill basically to ensure that when contracts are let between the lender and the commercial client, that it's explicitly written that Nevada laws apply? Is that the main goal?
Go ahead.
Senator Hammond, for the record, yes.
Thank you. And the way I understand and by the way, as a small businessman, capital is very important to small business people to fill the ebbs and flows of needs, especially during tax season. So I've depended on these loans quite a bit in the past, and I know that they're so important, and I certainly want to facilitate the ease of commercial, not consumer, but commercial opportunities. So with these alternative loans, as we're calling them, no collateral is required, correct?
For the record, Irv Nelson, that's correct. The freedom of contract applies here. So the borrower and the lender can have, for the most part, you know, whatever terms they want. They can say Nevada law applies, or they could say New York applies if they want. This is not.
Right.
This is not saying you have to apply Nevada law. What it's saying is, if your contract says Nevada law governs, that's a choice of law provision. It's the public policy of the state of Nevada to enforce that.
Okay. And these are arm's length loans, I assume, and there's probably no maximum amount. That's something that's negotiated between the client and the lender. And then just to reiterate, this bill is going to maintain the exemption that internet lenders have in not being licensed, and your type of loan isn't going to be licensed under this bill. Is that correct?
In
Nevada.
For the record, yes.
Thank you.
Additional questions? Okay. Any other presenters?
Madam Chair, no, this is it. So we'll step back and let you do your business.
Okay.
Thank you.
So we'll step back, and we will now open up public testimony in support. Those in support of Senate Bill 139, please come to the table. I don't see anyone in Las Vegas. Don't see anyone coming to the table in Carson City. Broadcast, do we have anyone on the phones?
You would like to testify in support of SB 139, please press star 9 now to take your place in the queue.
Wiz Rosard, W-I-Z-R-O-U-Z-A-R-D, Deputy State Director with Americans for Prosperity. And on behalf of thousands of activists, we'd like to definitely lend our support to this bill. We thank the bill sponsors, Senator Scott Hammond, for thinking of entrepreneurs and small business owners who often struggle to access capital. And when we talk about the internet, we're talking about access to new competition and new vehicles that can help lend to contributing to a diversification of our economy. So we wholeheartedly support this bill, and we greatly appreciate the considerations throughout the bill. And thank you, Chairwoman, for a well-run meeting.
Anyone else?
There are no callers choosing to testify at this time.
Okay, we'll now open up testimony in opposition. Testimony in opposition of Senate Bill 139. No one in Las Vegas. Seeing no one come to the table in Carson City. BPS, anyone on the phones?
If you would like to testify in opposition to SB 139, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
So we'll open up for those in neutral. Anyone testifying neutral? Here in Las Vegas, BPS, anyone on the phones?
If you would like to testify in neutral for SB 139, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Thank you. Sponsors, would you like closing statements? You good? Okay. All right, so we will now close the hearing on Senate Bill 139, and let's go to our work session. Mr. Megorejo.
Thank you, Madam Chair. For the record, Cesar Megorejo, Committee Policy Analyst. Our first bill on the work session today is Senate Bill 97, which enacts provisions governing the interstate practice of physical therapy. It was sponsored by Senator Sievers-Ganser and was heard on February 15, 2023. This bill enacts the Physical Therapy Licensure Compact. And Madam Chair, there are no amendments for this measure.
Thank you. Committee members, questions? I'll entertain a motion to pass. To pass. Senator Buck, motion, and Vice Chair Lang, second. Who was that? Was it? No, it was. Okay, yeah. Senator Buck, motion, and Vice Chair Lang, second. Further discussion? All in favor, aye. Aye. All opposed, nay. And the motion carries. And we'll assign the floor statement to Minority Leader Sievers-Ganser.
Thank you, Madam Chair. For the record, Cesar Megorejo, Committee Policy Analyst. Our next bill is Senate Bill 134, which revises provisions relating to vision insurance. This bill is sponsored by Senator Sievers-Ganser, Goicoechea, Titus, Buck, Stone, Harris, Pazina, and Assemblywoman Kasama et al. This bill was heard on March 13, 2023. This bill expands existing provisions, prohibitions on an insurer from entering into a contract with a provider of vision care that imposes certain conditions. And Madam Chair, there's no amendments.
Thank you. Any questions, committee members? I'll entertain a motion to pass.
So moved.
Have a motion from Senator Scheibel. Second. Senator Buck. All those in favor, aye. Aye. Opposed, nay. And the motion carries. Floor statement to Senator Seaver-Gansert.
Thank you, Madam Chair. For the record, Cesar Margarejo, Committee Policy Analyst. Next bill on the work session is Senate Bill 163, and it requires certain health insurance to cover treatment for certain conditions related to gender dysphoria, gender incongruence, and other disorders of sexual development. This bill is sponsored by Senator Scheibel, Harris, and Spearman, and it was heard on March 15, 2023. Senator Scheibel has submitted some amendments which are attached to this work session document. The first amendment is, and these amendments apply to various sections. And the first amendment is to amend subsection 1 to require insurance providing health insurance policies to include coverage for the medically necessary treatments related to gender dysphoria and gender incongruence unless otherwise excluded in this subsection. In addition, the amendment adds various medical professionals who can provide these treatments and specifies that cosmetic surgeries performed by plastic or reconstructive surgeons are excluded from this coverage. Amendment number 2 is to add a new subsection to these various sections to include provisions that prohibit insurers that issue a health insurance policy or healthcare plan, including Medicaid, from discriminating with respect to participation and coverage under the policy, contract, plan, or agreement against any person on the basis of actual gender identity or perceived gender identity. Amendment number 3 is to add a new subsection within these sections to include provisions that set forth what is considered as discrimination under these sections. Amendment number 4 is to add a new subsection under these various sections to prohibit certain insurers that issue health insurance policy or healthcare plan from applying categorical, cosmetic, or blanket exclusions to gender-affirming treatments or procedures, or any combination of or revisions to prior treatments determined to be medically necessary if the policy or plan also provides coverage for those services for purposes other than gender transition. In addition, insurers are required to evaluate services to include in the treatment of gender dysphoria that are indicated as medically appropriate under the World Professional Association for Transgender Health Standards of Care. Amendment number 5 is to amend subsection 2 of these various sections to delete other disorders of sexual development and increase from 17 years of age to 18 years of age the age limit for which certain insurers that issue a health insurance policy or healthcare plan may include additional requirements for the coverage of surgical gender affirming treatments in patients. Amendment number 6 is to amend subsection 3 of these various sections to provide that if, after reasonable effort, the insurer is unable to make available the benefits required by this bill, then coverage shall be processed as an out-of-network benefit according to the coverage provisions of the insurer. Amendment number 7 is to add a new subsection to these various sections to require that an appeal of a claim denied shall be decided in a manner consistent with the applicable statutes and in consultation with a healthcare provider with experience in prescribing or delivering gender-affirming treatment, who is required to provide input on the appropriateness of the denial of a claim and according to the appeal process of the insurer. And finally, add a new paragraph to subsection 5 of these various sections and subsection 2 of section 15 to define cosmetic surgery. And Madam Chair, that's all the amendments.
Thank you, committee members. Questions? Senator Scheibel.
Not so much a question. I just wanted to kind of review with everybody. We did have a conceptual amendment at the hearing on the bill, and this conceptual amendment is substantially similar. So I didn't is to spell out that insurance companies would not be required to cover cosmetic surgery. I know that was a serious concern for a lot of members and interested stakeholders. And so the new amendment provides that you can see it right there under section L of the coverage, that coverage for cosmetic surgery would not be included in the coverage, although other work performed by a plastic surgeon or reconstructive surgeon would be. And then we have a definition of cosmetic surgery, which was taken from an existing health plan. And it basically defines cosmetic surgery as an unnecessary procedure that is directed at improving an individual's appearance. So that's the first main change that we've made. The second one has to do with the section regarding care for minors, and we've added a reference at the end of that section to clarify that the insurance company itself can require parental consent for somebody under the age of 18, consistent with NRS 179.010 to 179.060, which is our minor consent statute, and it does not include any of the procedures addressed here. So that amendment is intended to clarify that parental consent can still be required for these treatments. And then there was one more amendment. Oh, and then the last amendment is to change so that if somebody has to seek out-of-network coverage, it is covered the same way as any other out-of-network coverage. They don't get it covered like it was in-network, same as anybody else would if they had to go see a specialist for their hearing or their orthopedics or their whatever. If it's out-of-network, it's out-of-network, and it will be reimbursed the way that any out-of-network claim is reimbursed. So those are the amendments to the amendment, and I appreciate everybody walking through that with me.
Thank you. Members, additional questions? I'll entertain a motion to amend to pass. So I have a motion from Senator Pazina. Do I have a second? Second from Vice Chair Lang. Additional questions, committee? All those in favor, aye. Oh, I'm sorry. Hold up, just.
Hi, Chair Spearman. I am going to be a yes today with my reservation on the floor.
Okay. Additional comments? Okay. Now, all those in favor, aye. Aye. Opposed, nay. And the ayes, with the exception of Senator Hammond and Senator Stone. And Senator Scheibel, you take the floor statement? Thank you.
Thank you, Madam Chair. For the record, Cesar Margaret, Committee Policy Analyst. Our next bill on the agenda is Senate Bill 277, which revises provisions relating to cannabis. This bill is sponsored by Senator Harris, and it was heard on April 10th, 2023. This Senate Bill 277 revises provisions establishing different requirements for cannabis cultivation, production, sale, and licensure based on adult use or medical establishments. The bill prohibits the Cannabis Compliance Board from issuing or renewing a medical cannabis establishment license on or after January 1, 2024, except in covered jurisdictions. The bill establishes a process for existing medical license holders to apply for an adult use license, which are deemed medical licenses for licensing limitations imposed in certain jurisdictions. The bill deems adult use establishments as dual licenses, allowing them to engage in medical cannabis activities, and exempts medical cannabis sales to the holders of a registry identification card or letter of approval from the excise tax. In addition, the bill repeals provisions concerning excluded felony offense and associated restrictions on licenses and registrants who have been convicted of an excluded felony offense. The bill increases the maximum fees for the adult use cannabis license issuance or renewal, and removes transaction limits for medical dispensaries, instead limiting any sale facility to 2.5 ounces of usable cannabis or 1/4 of an ounce for concentrated cannabis per transaction. Finally, the bill requires the Cannabis Advisory Commission to study the potential effects of removing cannabis from Schedule I controlled substances pursuant to Uniform Controlled Substance Act or the Federal Controlled Substance Act. The Commission must submit a report of its findings on or before March 1, 2024 to the Joint Interim Standing Committee on Judiciary and the Director of the Legislative Council Bureau for transmittal to the 83rd session of the Nevada Legislature. And Madam Chair, there was no amendment submitted by the sponsor of this bill.
Thank you. Committee members, questions, comments? I'll entertain a motion to pass. Have a motion by Vice Chair Lang. Do I have a second? Second from Senator Buck. Any further discussion? All those in favor, aye. Opposed, no. And the bill passes unanimously. We'll give the floor statement to Senator Harris.
Thank you, Madam Chair. For the record, Cesar Margaret, Committee Policy Analyst. Our next bill is Senate Bill 302, which revises provisions relating to health care, sponsored by Senators Orenthal, Scheibel, Spearman, Harris, Flores, et al. And it was heard on April 5th, 2023. Senator Orenthal has submitted some amendments that are attached in a draft mock-up to this work session document. The first amendment is to amend subsection 1 of section 1 to provide that no healthcare provider shall be subject to professional disciplinary action or adverse licensing outcomes by the respective board solely based on their involvement in providing or assisting with legally protected gender-affirming healthcare services. It also safeguards providers against disciplinary actions from other states or territories based on the same grounds as long as the services provided are lawful and meet relevant professional standards in the state. Amendment number 2 is to amend subsection 2 of section 1, subsection 3 of section 2, and subsection 4 of section 3 to revise the definition of gender-affirming services and to add a new paragraph under paragraph A of these respective subsections, and sections 2 provide that the term does not include conversion therapy. In addition, amend paragraph B of subsection 4 of section 3 to include court and judicial within the definition of state agency. And third amendment is to amend section 1 to provide that healthcare providers include pharmacies and pharmacists as used in this section. And actually, the third amendment and the fourth amendment are conceptual amendments that were provided by Senator Orenshaw. And the fourth amendment is to amend section 3 to extend the prohibitions imposed by this section to local governments. And Madam Chair, that's all the amendments.
Thank you, committee. Questions, comments? Entertain a motion to amend to pass.
So moved.
I have a motion, Senator Scheibel. Do I have a second? Second from Senator Pazina. Further discussion or questions, comments? All those in favor, aye. Aye. Opposed, nay. Nay. Ayes with the exception of Senator Stone, Senator Buck, and Senator Hammond. Floor statement to Senator Orenshaw.
Thank you, Madam Chair. For the record, Cesar Moncarejo, Committee Policy Analyst. Our next bill is Senate Bill 426, which revises provisions governing rent increases, and is sponsored by Senator Spearman and Assemblywoman Peters et al. It was heard on April 7th, 2023. There are several amendments that were discussed during the hearing of the bill that were presented in a draft mock-up. Attached to this is a mock-up that's actually prepared by the Legal Division of the Legislative Counsel Bureau. And, Madam Chair, there are some changes from the amendments discussed during the hearing, so I'll just run through them. The first amendment is to add sections 2.1 through 2.3 to provide definitions for various terms used throughout the bill. Amendment number 2 is to amend subsection 1 of section 5 to require a landlord to first petition the Housing Division and receive approval before increasing rent above the limitation and revise the circumstances which justify the exemption to the limitation of increasing the rent to obtain a fair return on their property. Amendment number 3 is to add subsection 2 to section 5 to require that the increase in rent for each additional occupant not exceed 5% for each additional occupant, and the increase in rent for additional occupants applies only for the period of time the additional occupant resides in the dwelling. Amendment number 4 is to add subsection 3 to section 5 to require that the increase in rent for capital improvements to a dwelling unit that primarily benefits the tenant not exceed 70% of the actual cost attributable to the dwelling unit plus imputed financing. Amendment number 5 is to add subsection 4 to section 5 to require that a tenant be provided a notice when their landlord submits an exemption to the rent increase limitations and the opportunity to present evidence in support of or opposition of the landlord's application. Amendment number 6 to amend subsection 5 of section 5 to require that the regulations adopted by the division include an amortization schedule for capital improvements, and add subsection 6 of section 5 to define various terms used throughout the section. Amendment number 8 is to add section 6.5 to prohibit retaliatory action by the landlord against a tenant by asserting or exercising rights, provide a reputable presumption that a landlord acted in retaliation under certain circumstances, authorize a tenant to use evidence that a landlord acted in retaliation as a defense, and authorize a tenant to bring a claim against the landlord for retaliation. And amendment number 9 is to delete section 7, which made conforming changes to the placement of the definition of cost of living increase in section 2. Madam Chair, that's all the amendments.
Thank you. Committee members, questions, comments? I know this was a highly contested piece of legislation, and trying to get to an amenable compromise that would not incur additional or energy on the part of landlords, but also to make sure that people who are and have been priced out of their homes, and it may not make sense to anyone until it happens to you. And so I want to commend Mr. Cather and others, all the other stakeholders who work together to come to this compromise. I always say to people, you know, the legislation that we pass, we try to do the best that we can, and sometimes if there are people who don't like it on both sides, that must mean it's pretty good. So I'll entertain a motion. Have a motion from Vice Chair Lang. Do I have a second? Second from Senator Scheibel. Further questions? All those in favor? Senator Stone.
Thank you, Madam Chair, and I certainly want to commend you for your efforts to try to alleviate financial pressures on people that are finding housing to be much more expensive. I unfortunately, as I mentioned in my comments during the discussion of this bill, remain opposed. I believe that the ones that you're truly trying to target, these corporate landlords, which are primarily responsible for the new development under this bill, are not going to have to pay or comply with this law for 15 years after they build their units. I think that creates an unfair playing field, especially for people like myself or other landlords that have been paying property taxes and making capital improvements in Nevada for years. I also think that the method of which a agency is going to allow for a percentage increase based on the CPI is convoluted. It's not clear. They couldn't even answer how a formula would dictate what a price, what an increase would incur. And then to have to go through the government for these exemptions is going to be time consuming. I'm not sure that they have the staffing levels to handle the volume of requests for exemptions, which means the landlord is going to have to wait 3 or 4 months before they can even get an answer, yet they have a contract for somebody that's going to be moving in. Again, while I appreciate your efforts, I just don't think this bill is fully cooked, and for those reasons, I can't support it.
Thank you. And Senator Stone, I believe one of the things that some of the people said in opposition was that it doesn't happen that much, and so if it doesn't happen that much, it probably will not require an exorbitant amount of staffing increases. So I hear you, and I appreciate your comments. But like I said, if the majority of people are doing the right thing, and it's just going to capture those who are not, then the amount of extra work or extra staffing, whatever FTEs someone might surmise, would probably be limited, if at all. But thank you so much. Senator Daley.
Thank you, Madam Chair. And I just was trying to review the amendment, various things, and I'm not going to hold it up getting out of committee. I think there's some merit to what we're trying to get done, and I do prefer this statewide approach to the home rule approach. So if we're going to go in a direction, I think this is the right one. I do have some concerns. I want to check into a couple of the amendments, but I think appreciate the effort. So.
Thank you. Senator Hammond?
Thank you, Chair. I think the effort is there, and the goal is there, and I may not be completely fully there yet, but I think I could with a little bit more time. So I'd like to just put that on the record and say that I want to review it a little bit more and talk with you a little bit more about it.
Thank you. And committee members, I know, as I said before, this was a rather contentious bill, and on both sides there was great merit and great passion. And the one thing that we as legislators don't have in our favor is time. We only meet every other year, and by the time we get back here, if we have not done something to at least alleviate the hardship on those who can least afford it, they have 18 months, 20 months, 24 months that they will have experienced something that is quite beyond their control. So I appreciate everyone's thoughtful attention to not only the bill but also to the amendments. And I will just say this: I would encourage you, if you have reservations, to make sure that you get with the stakeholders and see if you can bring some resolution to it. And hopefully sometime in the future, we will not have an antiquated system of legislation or legislature meetings, and we will move to someplace beyond every other year. If we had another session next year, guess what we could do, Senator Stone? We could see what it looks like and come back next year and fix whatever was broken. But we can't do that until 2025. And there'll probably be a lot of people who would be suffering, including good landlords. So, no further comments. I'll entertain a motion. I'm sorry, aye. Huh? Senator Lang and Senator Scheibel. Got it. So where are we now? Aye. All those in favor? Aye. All those opposed? Nay. Okay. So ayes, with the exception of Senator Stone, Senator Buck, and Senator Hammond. Is that where we are right now? Yeah. Okay. Oof.
You want to do the floor?
Yeah, I'll do floor statement.
Thank you, Chair. For the record, Cesar Magrejo, Committee Policy Analyst. Our last bill in the work session today is Senate Bill 427, which revises provisions relating to occupational safety and health, and was sponsored by the Senate Committee on Government Affairs and was heard on April 10, 2023. This bill revises provisions requiring employers to establish and implement a written safety program. Senator Flores did propose several conceptual amendments during the hearing of the bill. I'll just run through them really quick. And these are the same as those proposed during the hearing of the bill. So amend paragraph B of subsection 2 of section 1 to increase from 95 degrees Fahrenheit to 105 degrees Fahrenheit the temperature requirement for the program to mitigate heat illness. Amendment number 2 is to amend paragraphs B1, D2 of subsection 2, section 1 to delete fresh, pure, and cool. Number 3 is to amend paragraph B3 of subsection 2, section 1 to replace the current provision concerning breaks for employees to instead provide that the program to mitigate heat illness must include hydration periods for employees throughout the workday to prevent the occurrence of heat illness. Amendment number 4 is to amend paragraph D4 subsection 2, section 1 to replace the current provision concerning breaks for employees to instead provide that the program to mitigate exposure to poor air quality must include hydration periods for employees throughout the workday. Amendment number 5 is to add new provisions to the bill to exclude critical emergency infrastructure employees and emergency services personnel from the provisions of this bill. And amendment number 6 is to add new provisions to provide exceptions to the shade requirement in paragraph B3 of subsection 2, section 1, where an employee is working on a building and the shade requirement would create a safety hazard. Madam Chair, that's all the amendments.
Thank you. Questions, comments? Senator Buck?
Thank you, Chair Spearman. OSHA has the authority to regulate heat illness through the general duty clause of the existing law. Placing the requirements in statute is unnecessary, and the bill is too broad and doesn't take into consideration all the various industry differences. How do we monitor drivers for heat illness that are remote? What does cool water mean? Common sense for bad actors. Should not be legislated. Bring water to work with the rest of which is what the rest of the world does. The bill would still require shade at night, and I caution my colleagues as we should not enact a law that makes it easy to utilize the ambiguity within it as a weapon against business, and I'll be a no today.
Yeah. Senator Stone?
Thank you, Madam Chair, and I want to commend the author for recognizing that we have inclement weather, not only warm weather down in the south where I'm from, but obviously very cold weather up here, and certainly having rules and regulations governing employers to ensure that their workers are safe. I share some of the concerns of my colleague in the way that the bill is written, that the training is ambiguous, the heat standards, there's no source for those heat standards, and then under Health and Human Services, United States Health and Human Services, they have the National Institute for Occupational Safety and Health, NIOSH, which meticulously goes over these issues over 192 pages. So I think it's a duplication of effort. I think the federal government's got this pretty well covered, not only for Nevada, but across the United States. That puts an undue burden on businesses here in Nevada, and for those reasons, I won't be able to support the motion today.
Additional comments, questions? Okay, thank you. I'll entertain a motion. Have a motion from Vice Chair Lang. Second?
Second.
Second from Senator Scheibel. Additional questions or discussion? All those in favor, aye. Aye. Opposed, nay? Nay. And so ayes with the exception of Senator Stone, Senator Buck, and Senator Hammond. And we'll give the floor statement to Senator Flores. So we had one more bill on the agenda, but we're going to roll that till tomorrow, Senate Bill 436. And so we'll hear that first thing tomorrow. With that, I think we are ready for public comment. And anyone in Las Vegas? Oh, I'm sorry. Oh, one more. Sorry about that. So we heard Senate Bill 139 this morning, and I don't think we had any objections. So I want to move that forward. Committee members, any questions? Okay, so I'll entertain a motion. Have a motion from Vice Chair Lang, have a second from Senator Buck. Any additional questions? 139. Additional questions? Okay, all in favor, aye. Opposed, nay? And the ayes have it. And I think I'll ask Hammond. Floor statement? Okay. Okay, thank you. Now, we are ready for public comment. It's not yet noon, but it feels like this has been the longest week today. Public comment in Las Vegas, don't see anyone here. BPS, anyone on the phones?
If you would like to provide public comment, please press star 9 now to take your place in the queue. The public line is open and working. There are no callers at this time.
Okay, thank you. And with that, we will be adjourned until 8 o'clock tomorrow. We've got a lot of business to cover and a lot of road to go down, okay? So appreciate your cooperation. Thank you. We are now adjourned.